Hello, sir. Am I audible?
30 seconds will start the program.
Oh, okay, okay.
Hello, YouTube, sir. Hello, YouTube, sir. Good afternoon to all. With the permissions of today's resource person, Honorable Dr. D.N.S. Yadav, sir. Sir, shall we start? Shall we proceed further? Sir, shall we proceed further? Yes.
Yeah, we shall.
Yes. Thank you, sir.
I'm there.
Yes, sir. Good afternoon to all. I am Professor Dinesh Kolte, coordinator this online law lecture series on Indian Penal Code. Warmly welcome today's most respected, revered resource person, Honorable Dr. D.N.S. Yadav, sir, Senior Professor, Faculty of Law, University Lucknow. I heartily welcome all the participants throughout India. Today's resource person, sir, is going to enlighten us on the important topic, principles of criminal jurisprudence, with special reference to Indian Penal Code.
Okay.
Definitely, it will benefit us to understand the insights of IPC. Once again, I welcome today's research persons and all the participants in the third sessions of Indian Penal Code. Over to you, Akanksha.
A very warm evening to everyone. We are delighted to have with us today Dr. D.N.S. Yadav, sir, as a resource person for today's session, which will be on principles of criminal jurisprudence with the special reference to IPC. Now, I take this prerogative to introduce our guest speaker to you all. Dr. D.N.S. Yadav, sir, is currently a senior professor at Faculty of Law, University of Lucknow. Having a teaching experience of 24 years, Honorable Sir has completed BSc, LLB, LLM, LLD in mercantile law, and a specialization in criminal law law on constitution, law on evidence, and interpretation of statutes. He is visiting faculty to Yongsan University, South Korea. Has authored 6 books and different major chapters of the renowned books, also major volumes of international encyclopedias. Honorable Sir has published 27 articles at various national and international conferences, participated in more than 100 national and international conferences, also a visiting faculty at resource person for IAS PCS training officer, and delivered various talks on socially important and innovative topics. Respected Sir has been awarded as subject expert by Public Service Commission of Bihar, Patna, Jharkhand Ranchi, Uttarakhand Haridwar, UP Allahabad, and by UPSC New Delhi. He is also a member at Advisory Board United Nations Development Program, Government of India, in UP State Institute of Rural Development. Not just to this, Sir is also a resource person with UGC, HRDC to impart lectures to faculty member of higher education in their orientation and refreshers program. In the academic administrative service to the University of Lucknow, Sir has designated with several dignified posts such as Director, Second Campus, University of Lucknow, Legal Advisor to Vice Chancellor, University of Lucknow, Director at Legal Cell since 2006 till date, and many more. It is our honor and privilege to have such an eminent personality on our platform for today's session. Before we get started, there are few instructions for all the attendees. You all are requested to kindly mute your audio and video mode so that it could not create any hindrance in the ongoing session. This session will be followed by question and answer round. So if you have any question, you can simply put it in the chat box of your control panel, which will be answered by the speaker later. Now, I would request our guest speaker to please take over the charge and enlighten us all. Over to you, sir.
Thank you very much. Good evening. And I feel it is my great privilege to have this lecture on Indian Penal Code. Am I audible?
Yes,
Hello?
sir. You are audible, sir.
Yeah, thank you. So this is a great opportunity for me. And I'm grateful to Dr. Dinesh Kolche Saab, who gave me this opportunity to address on the series of for criminal law and all. And the topic which I have been assigned and which I will discuss, that is principles of criminal jurisprudence with a special reference to Indian Penal Code. What is criminal jurisprudence? First of all, let us understand that what is criminal jurisprudence. Criminal jurisprudence, in fact, deals with crimes and criminals. And of course, this jurisprudence related to crimes means if any person who has happened to commit crime, then of course, as per the criminal jurisprudence, he should be punished as per law. So for that particular purpose, lot many criminal laws are made by the various legislative bodies of countries all over the world. With regard to India, we have Indian Penal Code. And this Indian Penal Code was enacted by Britishers in the year 1860, as we know. And after we got independence from Britishers in the year 1947, and even today, after more than 74 years of independence, that Indian Penal Code is still in an operation. Means the law, Indian Penal Code, which was given to us by Britishers, that still we are carrying on that particular law. Questions may be there that why we are, still dealing with after independence a law which was given by given by Britishers when we were, ruled by them. Why didn't we made our own, Indian Penal Code after we got independence and all? So that would be a genuine question, and it is, very, very, ticklish issue. Sometime we will discuss it all, but today, as far as the topics which I have been assigned, I will discuss. Criminal law, Indian Penal Code is a major criminal law. And if we happen to talk about criminal jurisprudence, then we know that criminal jurisprudence constitutes not only Indian Penal Code, but it also includes Indian Evidence Act and Criminal Procedure Code. Whatever the crimes which are defined, whatever the offenses which are defined under IPC, this code was drafted, means you can call the architect of this Indian Penal Code was Lord Macaulay, and he drafted Indian Penal Code for Indians when we were under British rule in the year 1860. And IPC talks about certain acts or omissions which are declared to be offenses, and they are declared to be offenses under law, and they are made punishable by law. Offenses means those acts or omissions, of course, which society objects to. Like if somebody has been murdered, like if somebody's property is stolen, property looted, like there is some misappropriation of funds. So Indian Penal Code, under its different sections, defines various offenses. And of course, it also prescribes in the following sections punishment provided for those offenses under the law. For example, if we happen to see the category of offenses under Indian Penal Code, we will find that there are various categories of offenses defined under Indian Penal Code, like offenses against human body, like offenses against property, like offenses against women, like offenses against marriage, offenses against state, like different kind of categories provided under Indian Penal Code as offenses. For Indian Penal Code, for offenses against human body, like murder, like culpable homicide, like kidnapping, abduction, these are offenses against human body. Offenses against the property include theft, extortion, dacoity, criminal misappropriation of funds. Offenses against state include like sedition, charges of sedition and all, offenses against the state, offenses against women, like sexual offenses, rape, miscarriage, etc. So now the point is that what the offenses are defined under Indian Penal Code, and the purpose of law is that these all acts which are omissions, which are unlawful acts by one human being against another human being, law provides for that if any such unlawful act has been committed by one human being against another human being, and that's an unlawful act that is prohibited by law, means law prohibits that no one such commit such acts or omission which are declared to be offenses under Indian Penal Code, and if still people happen to commit those offenses, they happen to harm human body, they happen to harm properties like that. So law provides that once such prohibited acts are committed, means the Indian Penal Code provisions are violated, and once Indian Penal Code provisions are violated, then of course the same Indian Penal Code provides for Penal Code provides for what you call a punishment. Like for example, if you must be knowing, if we talk about section 302 of Indian Penal Code, then it's of course it's a section related to offense of murder, where one human being commits murder, kills another human being with an intention to kill him, with an intention to cause such harm, which he knows that is satisfactory to cause his death, or it is, just under all circumstances must cause his death, then of course under section 300, it has been provided under section 299 of Indian Penal Code, it has been provided that it will be offense of what you call culpable homicide, means killing of a human being by another human being with a guilty intention to cause his death. Murder is more aggravated form of what you call more aggravated form of culpable homicide, and followed by section 302, means offense of murder has been defined under section 300 of IPC, and punishment for this offense has been provided. Punishment for this offense has been provided under section 302. Now the point is that if punishment has to be provided, then under law, what the criminal jurisprudence talks about and what the co-relationship with Article 21 of the Constitution of India is that right to life and right to personal liberty and all. Now the person who has to be punished for offense of what you call murder, then of course he's going to be hanged by the court of law if the offenses are found proved. Then one of the punishments provided for the offense of murder, that is, death sentence. Now the law provides, what I'm trying to emphasize, that what the relationship has been between criminal jurisprudence, principles of criminal jurisprudence, and the IPC. Principles of criminal jurisprudence provides, you may note it down, that the principles of criminal jurisprudence provides that first of all, if any offense defined under Indian Penal Code has been committed, and for this particular purpose, for commission of the offense under Indian Penal Code, if the person accused who has been accused of commission of an offense, if he has to be punished, then automatically these principles, the principles of criminal jurisprudence, come into picture. That is number one, very important principle of criminal jurisprudence, that no person accused of an offense, will be convicted unless and until he is proved guilty, and he will be considered to be innocent. The point is that even offenses defined under Indian Penal Code, like offenses like murder, offenses like what you call kidnapping, abduction, offenses like what you call theft, extortion, robbery, dacoity, criminal misappropriation. The point is that what the criminal jurisprudence principles say, that the person who is accused of an offense, he will be considered to be innocent. Unless and until he is proved guilty. So, mere making allegations, mere making accusations that a particular person has committed crime, he has committed offense under Indian Penal Code, is not going to make him punishable under the law unless and until there are evidences to prove that he was a guilty person. Means he committed crime, he had intention to commit that crime, and there are evidences to prove that he's criminal, he's guilty and all. So first principle of criminal jurisprudence, as far as the criminal liability is concerned, that is, every person who is accused of an offense shall be presumed to be innocent in the eyes of law unless he is proved guilty. And what is proving guilty means? What is proving guilty means? For the purpose of proving guilty for those offenses so that the person accused can be punished under the law. इसको बोल दो ना, अभी रुक के बात फोन करते हैं, कांटेक्ट करते हैं. Sorry, I had an urgent call. Sorry for inconvenience. So what I was talking about is that a person who is accused of an offense, he will be presumed to be innocent in the eyes of law unless he is proved guilty. Presumption of law is that mere making allegations against a person for the commission of offense is not, sufficient unless the authority or the institution which makes allegation of commission of an offense against such person is in a position to prove that the person so accused is guilty of that offense. Guilty, proving guilty means you would need evidences. And once you need evidences, this is the evidence to prove, this is the evidence that this is not proved. So again, this is very important for the purpose of whatever the IPC offenses are there. Again, it is very important once there is a provision for punishment, and for the purpose of provision for punishment, a procedure has to be followed, because under criminal law, punishment under IPC, punishment, if you happen to see, section 53 of Indian Penal Code, section 53 of Indian Penal Code specifically provides the categories of punishment, what legally punishment could be given to the persons accused for the commission of the crime. So there are categories of offenses, punishments provided, right from, death sentence, then life imprisonment, then rigorous imprisonment, simple imprisonment, then fine. Sometimes a fine alone, sometimes it is imprisonment plus fine. So that way punishment is to be given. So these punishments come in direct, relationship with Article 21 of the Constitution of India. You must all be knowing the very significance of Article 21 of the Constitution of India. Article 21 of the Constitution of India provides for a fundamental right against right to life and against right to personal liberty. So by means of punishment for an offense which provides death punishment or which provides rigorous imprisonment, life imprisonment and all, it means the person is going to be hanged. Person is going to be hanged means his right to life is going to be violated. Person is going to be imprisoned by means of sending him to jail, conviction and all, to undergo punishment provided for the offense. Means his fundamental right to personal liberty is going to be violated. So under that circumstances, if his right to life is going to be violated, his personal liberty is going to be violated, then directly Article 21 of the Constitution of India comes into picture. And Article 21 of the Constitution of India provides that no person shall be deprived of his life and personal liberty except by a procedure established by law. And the procedure established by law means what I told you, that if a person has committed death of any other person, a person has killed any other person, then of course procedure has to be followed. The principles of criminal jurisprudence say that you cannot arbitrarily, you cannot unilaterally provide punishment to any person, even if he is accused of a crime. An accusation of a crime, making charges for a crime, does not mean that the person is found guilty unless and until whatever the IPC offenses have been committed, the person has to be proceeded with a procedure established by law, then only you can provide punishment. This another principle of criminal jurisprudence say that you have to follow the procedure established by law for the purpose of awarding punishment to the accused person to whom there is an allegation or there is a charge that he has committed any offense defined under Indian Penal Code. And this process is to be followed because there are two situations. Two situations means he can only be convicted or he can only be punished unless he is found guilty or proved guilty. And for the purpose of proving guilty, there must be evidences. So procedure to be followed for proving a person guilty of an offense under IPC, the principle of criminal jurisprudence say that first of all, a first information report, what is popularly known as FIR, first information report has to be registered once, whenever, in any part of our country, or any part of the police station having jurisdiction, any crime has been reported, any offense has been reported that a particular offense of Indian Penal Code has been committed, then first of all, the FIR is registered, first information report is registered at the concerned police station having jurisdiction. That is under section 154 of Criminal Procedure Code, if it is a cognizable offense, and under 155 of Criminal Procedure Code, if it is a non-cognizable offense. What is a cognizable offense? What is a non-cognizable offense? That is subject matter of CRPC, which is not going to discuss right now. But the point is that what the correlationship it has got with the Indian Penal Code as far as CRPC is concerned, then whatever the offenses defined under Indian Penal Code happen to be committed in the society, then first of all, the concerned police station registers first information report against those people who are suspected to have committed crime or those who are accused to have been committed crime. As far as accusation are concerned, as far as who are the suspects, means the person who come at the police station with a request to lodge the first information report, and they happen to be witnesses at the scene of the crime that such and such person happens to commit that particular crime. So FIR is to be registered. It is a piece of evidence. It is a piece of evidence, and this procedure has to be followed. And FIR, registration of FIR means the police will start investigation of the case. Purpose is to start investigation of the case. The purpose of investigation is collection of evidences. By means of conducting investigation of the case, police will collect evidences to prosecute the accused person in an effort so that he can be proved guilty. And after that, charge sheet has been filed before the competent court of law. If there are sufficient evidences found, to proceed with the prosecution proceedings against the accused person. And as we know, whatever the punishments provided under Indian Penal Code, police can investigate, police can register first information report, police can collect evidences, but police has no authority, to give any punishment, to award any punishment to the accused person. Because once this authority has been given to the police to award punishments which are provided under the Indian Penal Code for the offenses committed, means the police will be a biased party. He may be a party to the case. So for the purpose of maintaining neutrality, there is no, there is no injustice to the accused that way. this jurisdiction has been given to the criminal courts, and these criminal courts are established under Section 6 of CRPC. And there they will be, a trial will be conducted, and if they are found guilty, evidences are produced by the prosecution parties and all. Then, depending upon the evidences, whatever they produce, the court will decide for what is called, and that is whether he person has been found guilty or not found guilty. If has been found guilty, then of course he will be convicted, and if he is not found guilty, then of course he will be acquitted. So, in the beginning, we saw that no person accused of offense can be punished without evidence. He will be presumed to be innocent in the eyes of law unless he is proved guilty. And the proof, again, it is very important, and the procedure has to be followed in conformity with Article 21 of the Constitution of India, so that even if the accused person happened to be executed by hanging him to death by death sentence or life imprisonment or any kind of imprisonment and all, so his fundamental right under Article 21 is not violated. And of course, if he happens to be found guilty and proved guilty, then of course death sentence can be executed in accordance with law, and it is nowhere going to violate his fundamental right, because he has been found guilty of an offense like murder, which provides for death sentence under Indian Penal Code. Now the point is that, again, the principles go that you cannot, the state cannot, or the prosecution cannot, or the legal machinery cannot proceed unilaterally to executing the person accused, or the machinery cannot unilaterally award punishment without, again, it is an important point, without following the principles of natural justice. Even if you are going to proceed against the accused under the provisions of law by following the procedure established by law as is required under the Indian Constitution. But the point is that the principle of natural justice, that's a very important principle of natural justice has to be followed. Otherwise, whatever the punishment, principle of natural justice has not been taken into account, principle of natural justice has not been followed, and without following principles of natural justice, if the system has awarded punishment and found guilty and convicted the accused person, then such a kind of punishment will be absolutely illegal, will be absolutely unconstitutional. So that way, principles of natural justice means whatever the prosecution has made charges of offenses defined under Indian Penal Code, then without giving an opportunity of hearing, to the accused concerned, punishment cannot be awarded, because he has to be given a chance to defend himself. So now this becomes the accusation by the prosecution side, and that is why then when you happen to see the offenses Indian Penal Code when being run on the court of law, you will find there are two parties. One is prosecution side and the other is defense side. Prosecution side means police machinery is there, registration of FIR is there, investigation of FIR is there, collection of evidence for the purpose of prosecuting the accused person. But at the same time, there are government advocates also. They will conduct the prosecution before the trial courts and all. But at the same time, keeping in mind this very important principle of natural justice, that you cannot proceed with prosecution and you cannot provide any conviction or punishment and you cannot declare him to be guilty without affording him an opportunity of defense and without being given him, that is what is called opportunity of hearing. And this is in Latin terminology, that is what is called odi alteram partem. Odi alteram partem means the other party has to be given the opportunity of hearing, because he has to be given defense before being awarded any punishment, because if the case is to be conducted for the purpose of offenses under Indian Penal Code, there may be two situations. Either case found proved, or either case found proved guilty, or the case is not found proved guilty, or means that is not proved. Once it is not proved, no punishment. Once it is proved, then only punishment can be given according to law. So defense is also provided. You must be, it is very interesting to know for the law students that an accused has to be given opportunity of defense at the time of trial proceedings before the court of law, and this is his legal right for constitutional remedy, that he should be given defense. Now, it is an interesting point to note that Indian Penal Code itself provides for the situations that under these situations, any accused person can legally claim defense during the trial proceedings for, prosecution, when he's being prosecuted. So that is defense. So if you happen to see the Indian Penal Code, then there are chapters of general defenses. General defenses chapters, the general defenses are provided from section 76 to section 106. Section 76 of IPC to section 106 of IPC, there are general defenses provided, and under these general defenses, for the purpose of claim of these general defenses, any accused person who has been prosecuted by the prosecution side, by the state, he can claim those defenses legally with the help of his defense lawyer in the court of law, of all those defenses which are legally admissible to the accused person. And these defenses, you must see the Indian Penal Code, you will find a chapter of general defenses, and these general defenses from section, I will repeat again, from section 76 to section 106. I will give example of some of the general defenses which can be legally claimed by the accused at the time of trial proceedings, like what you call mistake of a fact, 76-79. 76-79 IPC provide for mistake of fact and mistake of law. Means if due to mistake of fact, any offense happens to be committed without intention, there was no intention to commit that crime, it was just mistake of fact that that offense happened to take place. Under that circumstances, the accused person will be given benefit, or you can call advantage, of section 76, section 79, mistake of fact and the mistake of law. Mistake of fact means what you call ignorantia facta, that's a Latin maximology. Ignorantia facta, exequat, and mistake of law is not excusable. That ignorantia juris non exequat means any person cannot claim as a mistake of law that I was ignorant about that particular law, so I was not knowing about that law, so by mistake I have to commit that particular offense, I was not knowing about that. So law says that ignorance of law is no excuse. You cannot take excuse that you were not aware of that particular law and ignorantly that offense took place, so I should be excused. Law says no. Under that circumstances, the defense of section 76, section 79 will not be available to the accused person. But yes, of course, a mistake of advantage of mistake of fact will be available to the accused persons. Again, if you proceed further, then you will find that anything, committed by a person who is, done by a person, any act committed by a person who considers himself to be bound by law, who considers himself to be justified by law, he did that particular committed without any intention. Then comes further sections like section 80 talks about that if there is an accident took place means there was no intention again, and out of accident only, without any, he took proper care, he had no, intention to commit, he was not having any wrongful intention. So by accident it took place, then of course the person will be getting defense of it. Section 80, 81, 80 through 81, 82 are also very important. 82, 83, 81 talks about inevitable accident. 82, 83 talk about law of defense in case of infancy. Infancy means those who are minors as per the age prescription given under Indian Penal Code, like 82 up to 7 years of age, 83 above 7 years of age, below 12 years of age. So if between these age group, if such minor people happen to commit crime, then the principle of law is that since such people being minority, they have not a mature mind, they have not properly developed mind, so they cannot possess any kind of criminal intention to commit any crime. So they have been, excused. This defense will be given to them. Then again, if you happen to come section 84 of Indian Penal Code, section 84 of Indian Penal Code talks about law on insanity. Insanity is a very important situation where due to insanity, a person who is insane means he has a kind of mental disorder. Due to any mental disease or due to any situation, he has got a mental disorder, and due to mental disorder, his mental faculty has been damaged, and because of damage to or mental disorder to his mental faculty, he is not in a position to understand the nature of the act as a normal man. This is a kind of abnormality. Under IPC, it has been provided this fact. If you happen to see IPC, and if you happen to go to the case law, McNaughton's case is a very important case. It is an English case, and based upon the McNaughton's case, McNaughton rules were framed, and on those McNaughton rules only, the section, the ingredients of section 84 were framed, that due to mental disorder, due to mental disease, or due to unsoundness of mind, the person was not in a position to understand the nature of the act, what was being committed, or even if the law says, or even if he was able to understand the nature of the act, he was not able to understand because of insanity that what he is going to do is unlawful, wrong, or what he is going to do that is punishable by law, that he was not able to understand because of, unsoundness of mind, insanity and all. So law make it very clear, McNaughton rules make it very clear, law on defense of section 84 IPC makes it very clear that even if any offense has been committed, suppose there is an allegation against B that he committed murder of C, and there is an eyewitness A who is the eyewitness to this particular fact, and he gives evidence before the court of law, or he gives a statement before the police after, at the time of investigation, that yes, he is eyewitness to the particular fact, that B murdered C before his own eyes. Okay, case was investigated by the police. Charge sheet was filed against B by the prosecution. And when at the time of trial, he was given opportunity of defense and all, then his defense advocate, at the time of producing his defense, he made argument before the court of law that, yes, my lord, he has committed death of C, but he is not criminally liable. He is not criminally liable. He is not guilty for that, because at the time of the commission of the crime, he was suffering from insanity, or he was suffering from unsoundness of mind. So once this is proved under the defense that yes, there is an evidence, and of course, if you happen to see that if a person is claiming the defense of insanity and all, then of course, whether at the time of the commission of the crime, whether the person who is claiming that he was insane or unsound at the time of the commission, of course, medical evidence will only be in a position to prove whether he was unsound or not at the commission of the crime. So medical evidence will be important. So for this particular purpose, if you go in detail for section 84 of, law on insanity and all, apart from McNaughton rules, you will also find that the medical insanity has been categorized into two kinds. One is medical insanity and the other is legal insanity. And for your information, for the purpose of discussion, this is very important for you to know that for the purpose of claiming the defense of insanity will be available only when the defense is in a position to prove that the accused was 100% insane, and 100% insanity is known as legal insanity. And if this legal insanity, 100% insanity, is below 100%, maybe he was 70%, medically insane, 30% he was all right, 60% his mind was medically insane, 40% was all right, means only 60% of his mind was unable to understand the things because of unsoundness. But medical evidence provides that 40% of his mind was quite, fit, and 40% part of the mind was able to understand properly. So under that circumstances, legal insanity will not be available, and depending upon the evidences, the court will proceed for granting, punishment and all. So for the purpose of getting defense by the defense side, they should in a position to prove that it was legal insanity and it was not medical insanity. Similarly, if you happen to see the cases of intoxication also, people used to take defense all that he was under the influence of liquor, he was not able to understand the nature of the act, so under the influence of the liquor he happened to commit crime. Then our IPC provisions like section 85, 86, and there are a number of case laws also which provide that no, this intoxication, maybe it is voluntary intoxication or maybe it is involuntary intoxication. If it was a voluntary intoxication, means the person came under intoxication willingly, there was no compulsion. Involuntary means he was forced to have this liquor and all, intoxication and all, drugs and all. So if it was involuntary intoxication, he was forced to death without his knowledge and all, then yes, law makes it clear. IPC also makes it clear that we will consider it to be as a defense because it was not voluntary, it was not taken willingly. It was not taken willingly. It was not taken willingly. Then of course some punishment will be. I mean, relaxation will be given to him. But the point is that if it is intoxication voluntary, then of course no defense, and the person will be punished and all. Then you come to another defenses like in good faith, like if you happen to see doctors, medical practitioners, they are committing operations of the body. I mean, people are suffering from very dangerous diseases, very harmful diseases, and the doctors, they know that for the purpose of saving the life of the patients, saving the life of the patient, they have to operate upon. So they have to operate upon, and there are chances that the person may die also during the operation. The person may die, and no doctor intends to kill any person. It is a very novel profession like that. Every doctor intends that he should save the life of the patient. But looking to the gravity and looking to the nature of the injury and all, if during the operation he is not able to save the life of the patient and the person dies, so there will be defense to the doctors that the doctor made all efforts to save the life of the person, and that was the only way out. Because without, doctor was convinced, other doctor was also convinced that without operating upon the patient, they won't be able to save the life of the person. And during operation, there was possibility also that the person may succumb to injuries because there were serious injuries and all. So under that circumstances, IPC clearly provides that if the doctor was operating upon the operation in good faith with a view to save the life of the person, that under circumstances, if during operation, if the patient happens to die, then this will not be a crime, this will not be a charge against the doctor that he killed the person by means of operation. Of course, criminal negligence will not be permitted. I mean, doctor is supposed to be quite careful while operating the operation. So if he was negligent, criminally negligent while operating upon, then of course the case will be made out against the doctor, because carelessness, negligence performing is duties of the doctor, that will not be, I mean, excused by the what you call, I mean, legal system. Another important defenses, and these are very important defenses under Indian Penal Code. They are from section 96 to section 106. You all must be knowing. These are very important defenses of what you call right to private defense. Right to private defense means law gives you a legal right if somebody happens to attack your body, or if somebody happens to attack your property, then under such circumstances, from section 96 to section 106 of IPC, there are provisions of right to private defense have been provided. That right of private defenses can be claimed if any person happens to attack your body or body of any other person, or any other person happens to attack your property or property belonging to any other person. Under that circumstances, if there is no recourse to public authority, we are not able to take the help of the public authorities and all against that attack, then law considers that you should not run away like a coward. Law says attack him. If he is attacking, then you defend yourself. If he is attacking, then you defend yourself from his attack. And during this defense, that is what is called right to private defense. And if during this defense, if such a situation arises that the person who attacked is killed by you, his death has been caused, then law says that it is excusable. Excusable in the sense, and for the purpose of this excusation, you can see section 96, you can see section 97, you can see section 98, 99. These are 99. There are certain restrictions provided, means uh, if you happen to understand the nature of these right of private defenses under IPC, under the section 96 to 106, you will see that the nature of these, defenses provided for against criminal prosecution and all as a part of criminal liability, these are, not absolute rights, and these rights are made subject to certain restrictions. And if person enjoying his right to private defense, at the time of defending his body or property, he should not use much force which is required to defend his body or property. Means in proportion to the attack, the nature of the attack. Suppose the attacker who is having no arms, he is armless, and he is attacking. So in proportion to the attack, the right of private defense should be applied. It does not mean that the person who was attacking your body or property, he was without any arms, and the other fellow then took out his revolver and killed him and claims that no, it was under the right of private defense. This will be illegal. Law says under section 99 that this is a restriction, that at the time of enjoying your right of private defense against the attacker, you are not given any authority under the law, not given any right under the law to use much force, comparatively much force, than it is required to defend yourself. So required to defend yourself means a person was without arms, he was just attacking you, he was just giving you a fist or just manhandling you or threatening you to kill and all. But he was not having any arm, he was not having any dangerous weapons, so that there was no any possibility or any, situation that he's going to kill you. And if claiming that you happen to take a revolver and kill him then and there, then law says that this is illegal because you exceeded those rights. The restriction is that, first of all, you will try to see that you should take first help of any public authority, so that you can take legal help against the attacker and catch hold of him, hand over him to the legal system, and let the legal system do the lawful action for getting punishment and all. So absolute right means it is said that this right you should use as a shield and you should not use as a weapon or as a sword. Means you have to defend yourself just like a shield, you have to defend yourself, and under the garb of defending yourself behind the curtain and all, you should not utilize this right as a punitive right. It is just a preventive right. You can just prevent your body, you can just prevent your property. For the prevention of your attack, you can just use these rights as a preventive right. And the moment you are going to use this right, what you call as a, punitive right, or you are going to attack the, using extra force, using excessive force, then necessary under the circumstances, then of course this will be going to be very much illegal and all, and then right of private defense will not be available to you. So that way, section 99 is very important, and this right of private defense provisions repeatedly say that whatever the right of private defense has been given to you, it is subject to the restrictions. It is subject to restrictions under Section 99 of Indian Penal Code. Yes, of course, there are questions asked sometimes. The people want to know that under what circumstances, what are the circumstances where the right of private defense can be exercised to the extent of killing causing death of the person, the accused person. So for that particular purpose, section 100 is very important. For that particular purpose, section 103 is very important. Section 100 IPC provides for, section 100 IPC provides for that at the time of body has been attacked and where there is, reasonable apprehension of death due to that particular attack. So under that circumstances, section 100 provides 7 situations that under that 7 situations, the life of the person can be, he can be killed, the person who attacked. And similarly, section 103 IPC provides for 4 situations, and under those 4 situations, the person whose property has been attacked can cause death of the person who attacked his property. So that way, there are very much restrictions. We can say that whatever the IPC provides, the principles are that you cannot exceed, using force more than it is necessary. First, you have to see that there was a recourse to public authorities for their help. And if there was a time to recourse to public authorities and without taking recourse to public authorities, without taking help of the public authorities, if you proceeded on, applying your right to private defense and causing harm to the person concerned, under that circumstances, right to private defense will not be available. So that way, these private defenses are provided for the purpose of the accused, not only, in the Indian Penal Code itself, and these sections 76 to 106, all defenses can be legally claimed by the accused person. And that is what the, advocates do. Whatever the advocates do as a defense lawyer, looking to the facts and circumstances of the case, they by examining those facts, by understanding, by reading out those statements of the, prosecution witness and all, they try to find out some situation. They try to find out some situations where they can get the advantage of these, defenses legally, and these defenses are provided none other than any other law but Indian Penal Code itself. The point is that if Indian Penal Code provides definition of offenses and the punishment for those offenses, at the same time, Indian Penal Code provisions also itself provide that these are the situations of defenses which can be legally claimed by the accused person. And as we discussed earlier, that this opportunity of defense has to be given by the prosecution system to the accused person. So once his legal claim is there that he should be given defense, opportunity, and once the defense opportunity has been given, then under that circumstances, by taking advantage of these defense opportunities, whether there was a mistake of fact, whether there was a mistake of law, whether it was a case of insanity, whether it was a case of infancy, or whether it was a case of intoxication, it was a case of, accident, or it was good faith doctor's defense and all, or it was right of private defense. So all these situations, if they are also proved, and the prosecution may be able to prove the, what is charges they are trying to prove, but at the same time, at the time when the defense has been given opportunity to prove his case, disprove his case, that he is innocent, because the defense always claims before the court of law that he is innocent. Charges are baseless. Whatever the charges leveled by the prosecution side under the IPC provisions are baseless. Okay, law gives provisions, law gives chance first to the accused, to the prosecution who brings the charges. And this is also very important, principle of criminal jurisprudence, that the prosecution has to prove the case first. Means case is brought to the court for the purpose of conducting trial. So under that circumstances, this is the requirement of the law, that once any accused has been produced before the court of law for the purpose of conducting trial, then we will apply first rule, that law will presume him to be innocent unless he is proved guilty. The law presumes him innocent and asks the prosecution side that since you have brought the charges, since you have brought the charge sheet, so you prove the case first. This is the rule. The prosecution has to prove the case first. And if the prosecution fails to prove the case, about the IPC provisions, offenses of the IPC provisions and all, then what will be the conclusion? If the prosecution who brings the charges and the law says and the rule says that you have brought the charges, so you have to prove the case first. Law will not go to ask the accused person, that you prove your innocence. No. Because law already presumes him to be innocent. So when he is presumed to be innocent, then law is not going to ask him that you prove your innocence. No. Law will first ask the prosecution side that you prove him you're guilty because you have come over with the charge sheet, you conducted the investigation of the case, you collected the evidence, and you prepared the charge sheet. So you must be having all material against the accused person to prove him guilty, to prove him first. And if he has to prove first, the principle of criminal jurisprudence say, and suppose the prosecution fails to prove the case, and if the prosecution fails to prove case, then what is the conclusion under the law? If the prosecution fails to prove the case, means prosecution has no evidence against the accused, and the prosecution has no evidence against the accused to prove him guilty. Then law takes a very obvious conclusion that your charge sheet is baseless. You made a case against the accused, that is arbitrarily, to harass him, because when there is no evidence, when you yourself is not in a position to prove the guilty, then why should I ask that you prove your innocence? First you prove, because you were given chance under the law to collect evidence and to investigate the case and to arrest the person and to prepare the charge sheet on the basis of evidences and come out for the trial and all. And if in trial you are failing to prove that case, means you have no evidence. And once you have no evidence, then of course accused is not guilty and we are going to set him free. So this is very important principle of, again, criminal jurisprudence first, that he should be given opportunity. Then the next principle is that prosecution has to prove the case first, and if the prosecution is, standard of proof is also provided under the rules, and the rule provide that what should be the standard of proof against the accused person. What should be the standard to be brought by the prosecution side to prove the case against the accused person? Then standard of proof, you should know that the case by the prosecution has to be proved first, then followed by the next very important rule or principle, what you call that the case must be proved beyond all reasonable doubts. Case must be proved beyond all reasonable doubts. Means if the case has been prepared and charges have been prepared by the prosecution, so at the time of proceeding for the trial, it is important duty of the prosecution that he should, or the prosecution should bring such an evidence which goes to prove the case beyond all reasonable doubt. There should be no doubt that he's an accused. There should be no doubt, undoubtedly, beyond all reasonable doubt. Then it further says that if there is even a shadow of doubt, then the benefit of doubt must be given to the accused person. That is again very important principle, that the prosecution has to prove the case beyond all reasonable doubt. Very strict standard of proof. Not only it is beyond doubt, but the standard is that beyond all reasonable doubt. Beyond all reasonable doubt is further defined, the further situation provided, that if there is even a shadow of doubt, forget about doubt. If there is even a shadow of doubt, then the benefit of doubt will always be given to the accused person. So, a very tough task has been put upon the soldiers of the prosecution side, like police force, like government advocates, public prosecutor and all, because criminal cases under IPC, they are based upon a strict interpretation of the Indian Penal Code provisions. And a strict interpretation is that either the person is guilty or the person is not guilty, nothing in between, either this way or that way. If the person fails to prove the case, law is blind and law is going to acquit the accused person and going to declare him to be not guilty. So that is why there is another important principle. The benefit of doubt will always be given to the accused person, because the law has to give final justice, complete justice, and under doubtful circumstances, law is not ready or system is not ready, our criminal jurisprudence is not ready to award any kind of punishment to the accused person under doubtful circumstances. Doubtful circumstances means to be or not to be. Doubtful case means case has not been completely proved. Maybe or may not be. He may be guilty, he may not be guilty. No, law is not going to consider the situation. Law wants that he is guilty under all circumstances. Know that he may be guilty, he may not be guilty, he may be guilty, he may not be guilty. So under these doubtful circumstances, law takes its own course and declares the person to be, not guilty by taking the principle into account. That is what is called a benefit of doubt. And the benefit of doubt always goes to the accused person based upon this important consideration that let 100 criminals go unpunished, but not a single person shall be punished under the doubtful circumstances. Law is not ready to punish any person who is innocent. So just saving the innocent person under doubtful conditions means case is not proved, half proved, half not proved. So half case is proved, 50% is proved, 50% not proved, means 50% is okay, 50% is doubtful. So even there is a shadow of doubtful, then case is not going to, court or system is not going to punish him. So following this consideration, that even let the 100 criminals go unpunished by taking benefit of doubt, let 100 criminals go unpunished by taking benefit of doubt, but not a single innocent person should be punished under doubtful circumstances. No doubt this could be understood it is a very old rule and very old principle. Now there are, our jurisprudence, criminal jurisprudence has got some change and all. that the people or very clever advocates, they used to take undue advantage of this particular principle, and some way or the other they try to conduct the case during trial proceedings just to create a situation so that a doubt is created in the mind of the court, and by means of creating a doubt in the mind of court, they try to argue this, I mean, situation before the court of law, and get their, I mean, clients or get their accused persons acquitted from punishment and all. So that way it has been felt now in the modern jurisprudence, modern criminal jurisprudence and all, that where it appears to the Supreme Court has given lot many considerations, that where it appears to be that, I mean, the defense lawyers, they are taking undue advantage of this particular, I mean, principle. So that way this should be very strictly taken into account, and they should not be given absolute benefit. Even if there is doubt, then court should examine very thoroughly the facts and circumstances of the case, and to establish the truth and proceed for the, I mean, punishment, or proceed for the punishment decision and all, without taking much into consideration. If the court, I mean, the advocates go on hammering for, I mean, it is, I mean, doubtful case, it is a doubt of doubt given. Under that circumstances, I mean, probably which we discussed, very important, and they are very established principles of criminal jurisprudence. And once criminal jurisprudence comes into picture, then our major criminal law under Indian criminal jurisprudence is Penal Code. And Indian Penal Code itself provides the liabilities, how to be taken upon, then offenses, how to be there punished, and there are very, I mean, various situations taken into consideration, like a person who is committing, like a person is committing, you call any case individual, he will be, there is a single person, there is a single person who commits an offense defined under penal code, then of course he will be having individual criminal liability. And the moment there are more than one persons, there are more than one persons who are in criminal period, then there is what is called joint liability. And under Indian Penal Code, you will find the concepts of joint liability under section 34 of Indian Penal Code, and under section 149 of Indian Penal Code. And joint liability concepts are under section 34, that's for common intention, and under section 149 for common object. Very important cases are there, like I mean, Mehboob Shah case is there, then um, Arvindo Kumar Ghosh case is there, in which is what defined that common for common liability and common, I mean, object and all, for common intention and all. These situations should be, I mean, proved, and the person can be liable under section 34 also. Under section 34, of course, is a rule of evidence under IPC, but section 149 provides for common object, where more than five or more than people they are involved. Like these cases are particularly taken into account, like bank dacoities and all, where there are five or more persons involved. And looking to the latest situation, where these are what you call this is um, mob lynching. Mob lynching cases, this is very difficult. Mob lynching cases, of course, is not defined under Indian Penal Code. And there were mob lynching cases where a mob of some 10, 20, 50 people, they are coming and they are lynching any person, and they are running away from the scene of the crime. And it becomes very difficult even for the police, and it becomes very difficult even for the courts to decide that who was in fact the person who was really involved in killing that, I mean, person. Because mob is a mob, and mob is a mob, and every person is coming and beating the other person. So it is very difficult to pinpoint that who gave him the, I mean, deadly blow, and because of that, the person's deadly blow, the person, I mean, succumbed to injuries and he was dead. So in that situation, court, I mean, says this 149 says, if there are mobbing cases, they are available. I mean, these principles are applicable, and Supreme Court also gave its decisions that either Parliament should make a law or make an amendment under the Indian Penal Code, and by means of making amendment under Indian Penal Code, the Parliament of India should declare, I mean, these mob lynching offences as a well-defined offence, a prohibited act and all, because till now there was no provision. There is no provision under Indian Penal Code that how to punish these, I mean, offenders who are, I mean, responsible for mob lynching and all. No evidence against anybody. They are coming in mob, they are killing a person in mob, and they are running away with mob. So court said, IPC also says, section 149 IPC says, in mob lynching offenses, whoever is there, who is the part of the crowd, 5 people are there, 10 people are there, 20 people are there, 15 people are there, whoever is there, whoever is present at the scene of the crime, then they all should be considered to be accused for that mob lynching. Since we are not in a position to pinpoint single individual or any two individual, then all persons collectively, that is what collective violence, then all people, they will be collectively made accused and they will be collectively made responsible for that particular mob lynching. Because law is not in a position to pinpoint, then it makes a very strict law. And this strict law is that even if you are the part of the crowd, you didn't give any blow to the person who was killed during mob lynching. But even if you are part of the crowd, then law considers that your presence over there, being in the mob of the, I mean, part of the crowd and all, it encourages the criminal, I mean, intention or the criminal mind of the mob. So that way they all are to be made responsible. What all happened in Arvindu Kumar Ghosh and Mehboob Shah Ghosh, they were all made responsible, whether they were party to the case or not, whether they were party to the crime or not. But their mere presence itself makes a difference. So that is why you might have seen that sometimes section 144 has been imposed. So there are 5 people, more than 5 people, they will be prosecuted, cases will be against, I mean, listed against them. And it's because of this mob mentality and mob, I mean, initiated crimes, though they are not defined, but nowadays, I mean, government of Rajasthan, state of Rajasthan, they have made a law on mob lynching, but the parliament or any others, it said we are still waiting for that there should be a case, I mean, there should be a law which deals with mob lynchers, so that, of course, they have to make the Indian Penal Code provisions only, or maybe, to my understanding, they may introduce some amendment under the Indian Penal Code and declaring any law under, I mean, 149 sections as ABCD, making them to be, I mean, mob lynching cases and making them prohibited offense and making them punishable under the law by taking into account section 145 and 149, where 5 or more persons are involved in the commission of the crime. Because these are committing very serious issues nowadays. In the last 5 years, 6 years, we are having lot many cases of mob lynching in Delhi, in Rajasthan, in Jharkhand, in Bihar, in UP itself. So that way, of course, Supreme Court has expressed its concern, and the Parliament is also, I mean, so take into account that the laws should be made for this particular, what you call, mob lynching cases and everything. One thing again in the last I shall be discussing with you, that under Indian Penal Code itself, where there are 2 or more persons committed crime, so there are cases of called conspiracy. Whether there was a conspiracy or not, what kind of conspiracy was there? Section 120 defines conspiracy. Section 120B, Section 120 defines conspiracy, and Section 120B makes provisions for punishment. Similarly, from section 100 onwards, IPC 108, 109, 110, 111, you will find offenses of abetment. I mean, some people, they are not directly involved in the commission of the crime. They may not be present at the scene of the crime. Suppose somebody is there, a person is there who is sitting in Dubai or Abu Dhabi, and from there he is abetting some people in Maharashtra, Mumbai to commit crimes and all. The person is sitting there in Abu Dhabi, person is sitting there in Dubai and all, and he is, instigating or abetting his own people in Maharashtra, Mumbai, Delhi, or other places that they should commit crime over there in India, Mumbai, like Mumbai bomb blast case. I mean, where there, Dubai people were involved. Daud Ibrahim name came into picture. They were not able to, hand it over to the government of India. That is a different issue. But these are all involved in your IPC provisions, like these abetments, section 107, 108, 109, 110, 111, 100, 111. And these all provisions provide for the nature of abetment, who the fellow abetted, how the fellow abetted, and whether the abetment was done and what the amendment was done in pursuance to that particular abetment, whether the offense was committed or not, and if abasement was committed, whether it was a deferred kind of intention or it was with similar intention, and what the punishment should be given to the person who is abettor, and what the punishment should be given who has been abetted. Of course, sometimes if the person abettor, he is situated in different country or different place, and crime takes place at a different place, because of this time, because of mobiles and all, because of electronic media and digital device and all, lot many, cases are reported where the cases are abetted from different place, and the cases committed at different place. That way evidence is not there, problem is there. Cyber crimes are of that reason. Cyber crimes, of course, there is a different law for cyber crimes and all, but looking to the dealing of cyber crimes, there are lot many amendments introduced under Indian Penal Code, Criminal Procedure Code, Indian Evidence Act. It is because of these problems that sometimes they are situated, they are out of India, and being out of India, they are abetting people, their people in India, to commit crime in India, to commit, terrorist attacks in India. So that way, this becomes a very difficult situation for prosecutors or the legal system to bring evidence and to prosecute them. So that is why sometimes we take the help of, under international law, we take the help of Interpol and all, that they should be, of course, they will be punished under the Indian Penal Code only. But because of their, situation, they were not in India, they were out of India. But of course, because of their abetment, an offense has been committed in India, people killed in India. So that, of course, Indian law has been violated. So that way, it is again a diplomatic situation where our government requests the other government or the other country where the accused person has taken asylum to hand over that fellow to us for the purpose of committing trial and avoiding punishment or not. Sometimes we are successful the getting persons from other country and proceed them, court trials and punish them. Sometimes we are not able to get them. So that way, this is the situation where, at international level also, IPC, no doubt, when it is an Indian Penal Code, it is applicable on the land of Indian, country only. But if any person happens to be Indian citizen and commits any crime other than India, so that way he will be supposed to be that he has committed crime in India only, and because he is an Indian citizen. So that way, wherever he will found, the court will, proceed with the system, will proceed with the punishment. To regards IPC provisions, my general statement will be that IPC, no doubt, is a good law, but looking to the present circumstances, we are taking this more than 150 years old law, and looking to technological development, looking to other situations, the gravity of crime and the nature of the crime has much more changed technologically. So that way, my suggestion would be that we now very seriously need that what you call a new Indian Penal Code, so that whatever the crimes being committed by taking help of technological development, by taking help of electronic media, cyber situations, digital media and all. So once they are defined under Indian Penal Code and they are made the part of Indian Penal Code, so this will be a collective law for the purpose of punishing all the persons, whether they are, going to the traditional mode of committing crimes or whether they are going to the digital modes of committing crimes and all. So that way, from my side, that is, discussion. If there is any question from the participants, sir, then they are at their liberty to make questions so that I can reply to their questions. Dr. Dinesh Kote, sir.
Yes, sir.
Hello.
Sir, thank you, sir. Sir, there is one question. Only one question is
Please,
there,
sir.
because after your thought-provoking presentation, there is one question from the
Thank you,
only
sir.
one question, sir.
What is question, sir?
Sir, any criminal matter evidence are important or eyewitness is important in IPC? There is one question from the Shan.
Eyewitnesses, and what's the question?
Sir, in any criminal matter, evidence are important or
Yes.
eyewitnesses important in IPC?
Evidences are important. Any criminal matter evidences are important. Not only criminal matter, for that particular situation, in civil matters also evidences are important. But evidences or eyewitnesses, they are not subject matter of Indian Penal Code, but they are subject matter of Indian Evidence Act. So eyewitnesses, they are defined under Indian Evidence Act. Evidence will be required because IPC, CRPC and Evidence Act, they are part of the criminal jurisprudence. Without the help of Evidence Act, IPC cannot go further. And without the help of the CRPC, Evidence Act is helpless, IPC is helpless. So that way they all make it, golden triangle of criminal jurisprudence, what you call. Without IPC, Evidence Act is useless, and without CRPC, IPC and Evidence Act is useless. So they all sit into a triangle and they make a very golden type of triangle for the purpose of successful implementation of criminal jurisprudence. And of course, evidences are very, very important for the purpose of proving offenses committed under IPC. Very important. And without evidences, case will fail and the person will not be able to get punishment and he will be out of the clutches of the law. So that is very important. But that is part of Indian Evidence Act. Once proceeding for IPC, what I mean to say is that one has to importantly, necessarily take into account the Indian Evidence Act, evidence, eyewitness, oral evidence, documentary evidence, circumstantial evidence, whatever the kind of evidence may be. Right.
Thank you, sir.
Any other
Sir,
question?
yes, one question is there from Anvesta Murthy. What is the difference between IPC and CRPC sections?
Yes. IPC, the basic difference is IPC and CRPC. If we happen to see the categories of law, then laws are of two categories. One is substantive law and other is procedural law. So under criminal jurisprudence, IPC is substantive law and CRPC is procedural law. Once offense committed in IPC, then for the purpose of proceeding for punishment and all, CRPC will be taken into consideration. So important distinction is that the Indian Penal Code is a substantive law. It defines rights and duties, and CRPC is a procedural law which is proceeded with for the purpose of enforcement of duties and enforcement of rights under IPC. Right, sir.
Thank you, sir. Sir, one question is there. If the weapon is not recovered by the police, how injury proof?
Yes, sir, pardon?
Sir, there is one question from the advocate Milind Chauhan. If the weapon is not recovered by the police, how injury proved?
Yeah. See, if weapon is not recovered, that is a part of laxity on the part of the police. But under criminal jurisprudence, there is again very important jurisprudence, that is what is called medical jurisprudence. For the purpose of looking into the nature of injury, seriousness of injury, medical evidence has to be taken, and medical evidence may, just like you might have heard post-mortem injury, what you might have heard anti-mortem injury. So post-mortem is to be done, anti-mortem is to be done by the doctors to ascertain the seriousness of the injury. So that way, even if weapon is not produced or weapon is not able to get, police is not able to get, but if these injuries, seriousness of injuries is concerned, that is to be proved by the doctor's medical report during post-mortem, report or anti-mortem report, whether it is an anti-mortem injury or it is a post-mortem injury. That is medical report. Yes.
Thank you, sir. Sir, another question is there from Shubham Pawar.
Yes.
If an accused before one sir. Sir, please can insert handcuffs to an accused before proving his offense. Is this right in angle of criminal jurisprudence?
See, handcuffing is prohibited. No doubt. He is very much clear ki it is right or wrong. But looking to the seriousness of the offense, if the accused happens to be a very, hardened criminal, or if he happens to be an terrorist and all, so if the prosecution feels like that looking to the criminal, he is very hardened, he can escape from the custody if he's not handcuffed and all, and he will cause serious, damage to the society and all. So looking at the situation of the law and order in public interest, he can be handcuffed. Otherwise, normally it is avoided, and it might have been seen lot many situations. The police, catch them by holding their by hand. They don't handcuff them, but under very, very exceptional circumstances, keeping in mind the hardened criminals, terrorist code, hardcore terrorists and all, yes, handcuffing is permitted in public interest.
Thank you, sir. Sir, there is a question from Ajad Rashid Sheikh.
Yes,
Sir,
sir.
is there any possibility of changes of IPC in coming years, as you suggested in your last minutes of presentation?
Any possibility of, sir?
Changes in IPC.
There is possibility, because as I have mentioned during my discussion and all, that the IPC has become very, very much old law. 1860 means 1860, 1960, 100 years, and this year more than 100 and more than 160 years old.
Yes, sir.
Much there is only we should be hopeful about that.
Yes, sir.
Right, sir.
I hope there is I think central government has instituted a committee
Yeah.
the committee to
The government
change in
can
this
form a
IPCs. Yes.
committee for the purpose of criminal law amendment in the
Yes.
issues and all.
Yes,
And once this committee submits its report, then of course the possibilities are there that we will be getting some more positive provisions under the IPC. This is very correct.
Thank you, sir.
Right.
Thank you, sir. All the questions you have answered. Thank you, sir.
Oh, thank you, doctor.
Thank you,
Over to
sir,
Akash.
for yes, sir. Thank you, sir, for clearing everyone's doubt and for bringing the conceptual clarity. Now we are at the verge of ending this session. I would like to take this opportunity to propose vote of thanks on the behalf of entire fraternity of Manikchand Pahade Law College. We express our gratitude towards our guest speaker for today's section, Dr. D.N.S. Yadav, sir, for taking his time out and for enriching us all with his words and knowledge. It will help us immensely in our future endeavors. I would also like to acknowledge our gratitude to our respected principal Dr. C.M. Rao sir and the teaching and non-teaching staff who has contributed to this event. At last, I thank all the attendees for their valuable presence and for being cooperative throughout the session. Be there tomorrow at the same time for the fourth session of this online lecture series on IPC, uh, which will be by Dr. Prabir Kumar Patnaik on a very informative and interesting topic that will be culpable homicide and murder. Thank you, sir.
Thank you. Thank you very much.
Thank you, sir. Sir, all the participants are informed that, see, in spite of today, sir is not in Lucknow. He has gone his native place because of some advertise and in the route. Sir has delivered the lecture to us. Sir, thank you, sir, for your kind guidance and generosity, sir.
Thank you. Thank you. Thank you, Doctor. Thank you, Doctor. Thank you.
Thank you, sir.
Nice.